Good morning, everyone. My name is Andrew Tobin, a partner at Mills and Reeve, specializing in insurance and reinsurance disputes. My co-presenters today are Jacqui King and Maeve Canavan of our London office, and we all work together on the case on the slide of Hamilton and Afghan Global and Anham. We acted for the successful insurers. Hamilton was the lead, and there were about 10 other insurers. We had a judgment in our client's favour in June of this year. In that judgment, the High Court agreed with our clients that Anham's claim for $41 million was very clearly not covered by the policy, and we'll be discussing the reasoning behind that this morning. It is an important decision for the London market because it is the first ever reported decision on a post 9/11 political violence insurance policy, and also because it establishes an important precedent regarding the interpretation of one of the political violence insurance market's standard wordings. Specifically, the judgment settles the meaning of both loss and seizure in this particular wording. The session is about 25 minutes. There's quite a lot that could be said about this case, but in the time available, we're just going to try and focus on the main points. If you have questions as you go along, please put them in the question and answer box, and my colleague Harriet Strevens will collate them for us to try to answer at the end. And of course, if you'd like to discuss anything about this decision directly with Jacqui, Maeve, or myself, please do contact us directly. We're always willing to have an informal chat. So I'll set the scene, and Jacqui and Maeve will do the difficult parts, which is to discuss the judgment. The original insured was Anham, a company headquartered in Virginia. They were the main food and logistics contractor to the US military. They owned and managed an enormous warehouse at Bagram Air Base in Afghanistan, which was the risk insured and is shown on the right-hand slide. It was 1.3 million square feet, which makes it one of the largest buildings in the world. Now, Anham was the original insured and warehouse owner. The reinsured was the Afghan Global Insurance Company, who were 100% reinsured into London by our clients, the reinsurers, on a facultative basis. The program limit was $41 million, placed in 2 layers, both of which were subject to English law and arbitration. I should say in passing at this point that Afghan Global played no active part in the proceedings that we're about to discuss. But I just want to flag at the outset the insurable interest on the reinsurance, which we'll come back to, but you'll see that it mentions that it was in respect of property damage only, as a result of direct physical loss or damage to the interest insured caused by, and then there follow various political violence perils such as riots, insurrection, revolution, coup d'etat, and so on, to the insured's physical assets. But Jacqui and Maeve will come back to that in a bit more detail. Now, it was a condition of the reinsurance placed in London that it would only respond to claims that would be admissible under a specific attached wordings. In other words, the reinsurance was placed on the basis of a deemed original wording. That deemed original wording was attached to the reinsurance slip and was the Beazley 7-point political violence wording, which is in wide circulation in the market and which also included an English law and arbitration provision. Now, the Beazley wording is one of the common political violence wordings used in the market. Essentially, it's a specialist type of property insurance policy by which insurers can buy cover against certain named political violence perils that are typically excluded under standard property insurance policies. It operates on a named perils basis. Insurers can select from a menu of 7 defined political violence perils, from terrorism, sabotage, through to insurrection, revolution, coup d'etat, and up to civil war itself. So the point is, however, that any policy issued by AGI to Anham should have been in that deemed Beazley form. In fact, however, it seems, or it emerged during the course of our case, that no actual underlying policy was ever produced. Certainly, it's never produced to reinsurers. So what happened? In February 2020, there were agreements between the United States and the Taliban, and also another agreement between the United States and the official Afghan government, under which the US agreed a timetable to withdraw. By May or June of 2021, the Taliban felt that the US and the allies were dragging their feet, and they started taking over cities and provinces one by one. And by July 21, the US started withdrawing in earnest. The Taliban kept closing in on Kabul, and by the 15th of August, they were in Kabul and Parwan province, which is where this warehouse was situated. And by the 16th of August, they'd taken over the warehouse, and Anham lost contact with its remaining staff there. So turning to the loss notification, on the 17th of August, reinsurers received a loss notification directly from Anham via the London brokers that the facility had been, quote, seized, taken by armed individuals who are part of or associated with the Taliban. And in December 2021, a proof of loss was sent to reinsurers saying that Anham has, quote, sustained a total loss of the warehouse resulting from insurrection, revolution, rebellion, civil war, and or coup d'etat, and that the Taliban had taken control of the warehouse by force of arms and had, quote, taken armed possession of the warehouse. It was also said that the Taliban were in possession of the warehouse and were planning to auction it off. So reinsurers identified and raised several defenses in correspondence with Anham, which were eventually articulated in pleadings, including avoidance for non-disclosure of certain allegations of fraud. We pointed out that there was no privity of contract between Anham and reinsurers, and so the direct claim that they were trying to make was unsustainable. We pointed out that there was no local policy at all, and there couldn't be a subsisting reinsurance without the existence of an actual insurance policy, and there were various quantum defenses. But the two defenses that we're going to talk a bit more today about concerned the point that the policy here covers only damage to property and does not cover deprivation of property. And also that the policy contained an exclusion 4.2, which excluded loss directly or indirectly caused by seizure, confiscation, and nationalization. We call that amongst ourselves, the political risk exclusion. So just for good order at this point, I should point out here that Anham disagreed with all of reinsurers' arguments. The final 2 points that I just mentioned were the points that were determined by the High Court in our judgment, and that was sufficient for reinsurers to defeat the substance of the claim for money. But formally, the former defences that I mentioned have not yet been adjudicated upon, and in theory remain in dispute for the time being. But what happened after that initial round of correspondence? Bearing in mind that contractually, if Anham wanted to make an insurance claim, it should have started an arbitration against the Afghan Global Insurance Company under an LCIA arbitration under the local policy. But Anham didn't do that. They sued reinsurers directly in the US federal court for the Southern District of New York for $41 million, plus punitive damages, jury trial, and so on. They also obtained an interim US injunction preventing reinsurers from going to the High Court in London for help. Now, Anham's direct action against reinsurers in the US was fundamentally misconceived for two reasons. Firstly, as this was a reinsurance arrangement, reinsurers had no direct contracts with Anham. And secondly, both the reinsurance and deemed original wording were expressly subject to English law and to LCIA arbitration in London. Working with US lawyers, we were able to have that case against reinsurers in New York dismissed, and we have obtained an anti-suit injunctions from the High Court in London against Anham, preventing the US proceedings from being reactivated against them. Reinsurers then started their own proceedings in London, seeking declarations of non-liability against both AGI and Anham based on all of the defences mentioned above. So that brings the case into the courts of England. So I'll now hand over to Jacqui, who will discuss what happened next.
Thanks, Andrew. So following close of pleadings, in December 2023, reinsurers filed an application seeking summary judgment. In simple terms, summary judgment is a means by which a party can seek an early determination of a case without the need to go to a full trial. Reinsurers sought summary judgment on two grounds. The first ground was that Anham's loss was directly or indirectly caused by the Taliban seizing the warehouse, and seizure was excluded by Policy Exclusion 4.2. The second ground was that the reinsurances only covered Anham's loss arising from property damage, and it did not cover loss arising from deprivation consequent upon the seizure of the warehouse. And we'll now talk you through the detail of what was argued by both parties and what the court decided in relation to each ground. In relation to reinsurers' ground one argument, that Anham's loss was caused by seizure and therefore excluded, Anham raised a number of objections. First, Anham argued that Exclusion 4.2 did not apply because it only excluded loss caused by seizure if that seizure was undertaken by a governing authority. Anham argued that the Taliban was not a governing authority when it seized the warehouse, and therefore Exclusion 4.2 was not relevant. To support this argument, Anham pointed to the words governing authority that appear in Exclusion 4.2. As you can see on the slide, the words governing authority appear on the fourth line, and Anham argued that those words qualified all the words that came before it. They also argued that the meaning of the word seizure takes its colour from the meaning of the other words around it. So Anham argued that words such as confiscation and nationalisation could only be acts of governing authorities. On that basis, they argued that seizure must therefore mean seizure by a governing authority only. Further, Anham said that its interpretation of the word seizure was consistent with what it said was the commercial purpose of a political violence policy. Anham argued that the commercial purpose was to ensure against non-governmental actions only. On that basis, it cannot have been the intention of Exclusion 4.2 to exclude actions by non-governments. They distinguished this from political risk policies, which Anham argued was concerned with covering governmental actions. Finally, Anham argued that the risk of the Taliban seizing the warehouse was in the contemplation of the parties, and for that reason, it must have been intended that the risk be covered as opposed to excluded. So in response to Anham's objections, reinsurers maintained that Exclusion 4.2 was applicable to the seizure of the warehouse for a number of reasons. First, reinsurers argued that the word seizure had a settled meaning based on established case law going back many years and, in fact, centuries. This case law demonstrated that the word seizure was already understood by the courts to mean all acts of forcible possession by a lawful authority or overpowering force, and further, it was not limited to acts of government or sovereign power, as suggested by Anham. Reinsurers argued that there was no reason to depart from this settled meaning, and Anham should have known this when it bought the insurance. It was a sophisticated buyer of insurance and was advised by specialist brokers. Reinsurers also put forward various explanations as to why the application of 4.2 was not limited to seizure by governing authorities. First, reinsurers looked at the construction of Exclusion 4.2, which they said could be split into three distinct parts, and you can see on the slide how reinsurers divided the clause. As you can see, each section starts with the words loss or damage, which you can see in blue. Each section has its own causal language, which you can see in pink. We've got caused by, and arising from. And each section is separated by the word nor, which you can see in green. The words governing authority only sit in part 2 and therefore could not be said to qualify either parts 1 or 3. Accordingly, as seizure sat within part 1 of the exclusion, it was not qualified by the words governing authority. In response to Anham's argument that the meaning of seizure should take colour from the words around it, reinsurers argued that these other words were not confined to acts of government. For example, illegal occupation is not necessarily the act of a governing authority. Reinsurers also argued that their interpretation was consistent with the broader structure of the policy. Whereas Anham attempted to distinguish a political violence policy as concerned with covering acts of non-governments, reinsurers argued that it was in fact concerned with covering loss arising from political violence and the property damage that ensued. Whether that political violence was by a government or non-government was not relevant. For instance, one of the insured perils under a policy is for war, which may well be an act of government rather than non-government. Moving on to the judgment, the judge agreed with reinsurers on all points in relation to ground 1. He agreed that the meaning of seizure was well established by case law and adopted that same meaning. In other words, the meaning of seizure remains all acts of taking forcible possession either by lawful authority or by overpowering force. He agreed that the meaning of seizure would be given its ordinary meaning and established for the purposes of reinsurances. The judge further accepted reinsurers' breakdown of the exclusion into 3 parts and agreed that this meant that the word seizure was not qualified by the words governing authority. He also agreed that a political violence policy was concerned with political violence and that was not restricted to non-government actors. Reinsurers were therefore successful in respect of their ground 1 argument that exclusion 4.2 served to exclude Anham's loss. And I'll hand over to Maeve now to talk you through the arguments in relation to ground 2.
Jacqui. So as mentioned, reinsurers sought summary judgment on 2 bases. The second being that under the reinsurances, there was only cover for property damage, not for deprivation loss. The diagram on screen refers briefly to each of the points relied on by reinsurers in support of their position, and I'll talk through them in a little bit more detail now. Starting at the top, reinsurers relied on the interest provision in the policy, which, as you can see, referred to property damage only. They also relied on the fact that the deemed original wording was entitled Political Violence Insurance Property Damage Wording. Building on these points, we submitted that damage should be given its ordinary meaning. That is, that there must be a change in physical state, and it does not mean deprivation loss. Next, we submitted that the fact the reinsurance covered physical damage was consistent with the rest of the policy. The insured perils, such as war or coup d'etat, were likely to entail violence and therefore damage to property. There were also provisions for the quantification of loss, how to calculate the cost of repair and replacement, etc., etc. Ultimately, reinsurers' position was that, under the insuring clause, property damage meant partial damage to the property, and property loss meant total damage to the property. There was not cover for deprivation loss. So, how did Anham respond? Anham submitted that under true construction of the reinsurances, there was cover for deprivation loss, and that its loss was akin to theft of property. In the alternative, that following the Marine Insurance Act, its loss was equivalent to actual total loss, as it had been irretrievably deprived of the property. Moving on to the judgment. In preparing for this presentation, Harry asked me if I could think of a creative way to present so that it wasn't just words on the slide. I have tried, but you may need to use your imagination a little. So, the court disagreed with Anham that there was cover for deprivation loss and found that only property damage was covered by the policies. The court relied on the clear wording of the policies, namely the interest provision, which, as already mentioned, provided cover in respect of property damage only as a result of direct physical loss of or damage to the interest insured. The natural and ordinary meaning of damage required some altered state, and there'd been no change to the physical state of the warehouse in this case. So looking at the slide, had the warehouse suffered damage like the building on the left, subject to our other arguments, it may have fallen for cover, but it hadn't, and therefore there couldn't be any cover. The court agreed that property damage was covered by reason of direct physical loss, meaning total loss, or damage to, meaning partial loss, of the warehouse, not merely the loss of use of the property. On that basis, the court also rejected Anham's alternative argument that there was a total loss as it had been irretrievably deprived of possession of its property, as irretrievable loss had not been envisaged by the policy wording. The court also rejected Anham's submission that because the indemnity could be calculated by reference to the costs of replacing the property, there was cover even where there was no property damage. The court reasoned that the question as to whether a property is repaired or replaced in a physical damage policy will depend on the extent of the physical damage inflicted upon it by the insured peril. Ultimately, the court concluded that the policies afforded cover in respect of political violence risks and consequent property damage, not political risks and consequent deprivation loss. So what happens if a peril falls within the insuring clause and an exclusion? In this case, it was common ground that the loss was caused by seizure by the Taliban. That much had been admitted by Anham when they first reported their loss, and it wasn't something they could row back from. However, Mr. Justice Calvert found that even if the loss was concurrently caused by an insured peril, for example, coup d'etat and seizure, the loss would still be excluded following the reasoning of the Supreme Court in B. Atlantic. In that case, a large amount of cocaine was discovered strapped to the hull of a vessel preparing to leave Venezuela. The vessel was detained by the authorities and confiscated, and the owner abandoned the vessel and claimed for a constructive total loss on its war risks policy, which covered loss caused by any person acting maliciously. The owner was not privy to the attempted drug smuggling, which was carried out by unconnected persons. However, insurers denied cover and sought to rely on the exclusion arising from detainment by reason of infringement of customs regulations. In that case, effect was given to the exclusion, even though the loss was caused by a combination of both persons acting maliciously and a breach of the customs regulations. Following that ruling, Mr. Justice Calvert found that it was not relevant in our case that an insured peril may have been operating at the time of Anham's loss. That construction was reinforced by reason of the fact that Clause 4.2 applied where the loss was directly or indirectly caused by seizure, so that if the seizure had a role to play in the cause of the loss, even if it was not the proximate cause and was only an indirect cause, the exclusion would still apply. So this case has again highlighted the power of direct causation language, which is often underestimated by many.
Well, thank you very much, Maeve and Jacqui. Falls to me to wrap up. What has the practical impact of this case been? Well, the judgment is binding as to the interpretation of the Beazley 7-point wording on two particular points. Firstly, it's very clear that from the judgment that the policy covers only damage to property and it does not cover deprivation of property. And perhaps the key central finding of the case is that quote on the slide that Maeve mentioned: the reinsurances, which were basically in the Beazley 7-point form, afford cover in respect of political violence risks and consequent property damage, not political risks and consequent deprivation loss. And the second point, binding point of the judgment, is that the excluded peril of seizure means, quote, all acts of taking forcible possession either by a lawful authority or by overpowering force. So it's clear that seizure in this wording, as it has been in many other wordings over the centuries, does not need to be by a governing authority, does not necessarily need to be by a governing authority. In general terms, the reaction amongst the market has been that the court obviously reached the right result. because when these policies were drafted 10 or 15 years ago, great care was taken to ensure that they were simply buybacks to ordinary property covers, and that there was no way that political risk cover could be inadvertently added in. Whilst many people say that the court reached the right judgment, many people have also welcomed the fact that there's now a public judgment on the record that everyone can now rely on to bring a greater degree of certainty about how this Beazley standard PV wording should be interpreted. And of course, we only now have a binding judgment because this case found its way into the High Court through an unusual route. Very often, these policies are subject to arbitration clauses, and decisions are made in secret. But we now have a clarifying judgment that everyone can rely on. So that concludes our presentation, or the main part of our presentation. Harriet, have we received any questions?
We do have one or two, but we have very limited time, so I'm going to rush through this one rather than miss it altogether, and I think directed at Jacqui. Why were the coverage arguments suitable for summary judgment?
So a summary judgment is usually suitable for issues and cases that don't require the court to consider extensive factual or witness evidence. It is, however, appropriate for issues that are confined to consideration of case law only. And for that reason, reinsurers' coverage arguments were suitable for summary judgment because it didn't require the court to look at any factual or witness evidence. And it was actually something the court had to consider in the course of the summary judgment hearing, because Anham had argued that it wasn't suitable for summary judgment. But in the judge's judgment, you can see that the court was satisfied it had everything it needed and for it to reach a decision.
So for once, everything in the right place at the right time, one might say. Very, very briefly, Andrew, if you can, what about the outcome? Would it have been any different under foreign law?
Well, actually, our next cover talk at the end of November is about the importance of law and jurisdiction. But essentially, this was a wording clearly and carefully drafted by English lawyers against the backdrop of hundreds of years of case law. And if you take any English law wording, not just political violence wordings, but whatever it is, and you make it subject to the laws of a different jurisdiction, it can be like taking a fish out of water. You don't know if that fish is going to survive or not. For a number of reasons, foreign legal systems all have their own approaches to interpretation, their own case law, their own rules, and it's just simply wrong to assume that they will take the same approach as English law would. And so there's no guarantee that things would be the same. A lot of the disputes around these products in particular in the last 15 years or so have in fact been greatly complicated by the fact that overseas legal systems have been applied to these wordings. I mean, there's quite a lot more that can be said on this, but I mean, everyone should ask themselves, or perhaps the underwriters should ask themselves, I mean, do they really know when they're underwriting what approach the foreign courts will take to the interpretation of this policy and the exclusions? It won't necessarily be the same. It'd be the same as English law. But anyway, I can hear you're anxious for me to wrap up, Harriet. So I'll button it there. So
we'll be accused of going over time otherwise. I'll pass it back to you to finish up for today. Thank you.
Okay. Well, thank you very much for joining us today. Yes, there's probably things we didn't cover. Please do contact Jacqui, myself, or Maeve. Whatever you wish. We're always happy to have a chat or a coffee or whatever suits. And also, please do join us for our next cover talk, which is on the 28th of November, when our speakers Tom Grant and Dan Pearson will discuss why governing law and jurisdiction is crucial. So picking up on what we just discussed. Don't miss that. Thank you very much, everyone. Have a great day.